Hi, my name is Karen Greenhall. I'm Executive Director of Civic Innovations, and with me is our Program Director, Zach Sykes. You may remember us from having been in Richmond. We served in the House of Delegates representing Virginia Beach. But we were talking about the statement by President Trump that he was going to issue an executive order to try and take control of mail-in ballots. And it's caused a lot of discussion, a lot of opinions, and not all of it is factual. And so Zach was explaining to me the ins and outs of what the president can and can't do. And we just thought it would be good information to share. Can you give a summary, Zach?
Yeah. So this was announced last Monday, so over a week ago. The president announced that he was going to lead a movement to get rid of mail-in ballots and voting machines, purporting that they are responsible for enabling, in his own words, massive fraud, and that he plans to advance this goal via executive order. We have not seen anything about this executive order yet. So there's still no word on it. So there's still a lot of speculation, and so far, I think the kind of the media coverage on it has been a bit thin, not really getting into the details of the implications of it, and that's what we're hoping to kind of supplement here.
Okay. It came as a big surprise to me because when I ran in 2021, mail-in ballots were not a big issue. But when I ran for reelection for 2023, it was a big push. The Republican Party all over Virginia, led by the governor's PAC, the Spirit of Virginia. Um, they got every city committee in the party was focused on getting people to sign up to do mail-in ballots. It was the big drive and seen as how the election would be won. There were some drawbacks. It seemed as though the most of the people who signed up were people that would have voted anyway. And where to me, the whole purpose would have been to go and, encourage people who didn't typically vote, or if it were a rainy day, wouldn't be motivated enough to go out, to get them to, here's a ballot, comes in the mail, fill it in, sign it, it's done, just to encourage people to vote. And yeah, that was a big difference in the perspective of the Republican Party from 2 years ago to what it is today.
Yeah, it definitely seems like it's a strategic about face. I mean, I know the president himself, if I'm not mistaken, he announced that he was going to vote by mail. I think from Florida, where he's a registered voter. And there was a big push in 2023 and 2024 with Republican state central committees and local city and county committees, really trying to get people signed up for it, especially their low propensity but otherwise reliable Republican voters, like the ones who, when it comes to a presidential election, they'll come out and vote for a Republican. But for state or local elections, it's not that they wouldn't vote Republican. It's just that they kind of sit them out. So those are called your GOTV, your GOTVs, or your get out to vote voters. The ones that you try and motivate, and Democrats have had a strong lead on this since at least the 2008 presidential campaign, where it was kind of pioneered getting people signed up for mail-in ballots and absentee ballots in President Barack Obama's campaign. So yeah, it definitely seems like they're kind of walking. Well, at least the president is walking it all back.
Well,
I'm
legally,
not.
is there anything legally he can do?
No, that's kind of that's kind of the other part of this, where as far as the strategic side of it politically, there's also the legal side of it. So in his announcement of his the executive order he says is being drafted, he explained, and quote, remember, the states are merely an agent for the federal government in counting and tabulating the votes. They must do what the federal government, as represented by the President of the United States, tell them for the good of our country to do. So there's two pretty big problems with that. The first one is that states are not just agents of the federal government. They're the primary regulator of congressional elections, always have been. Second, the federal authority uh, to preempt state election regulations is vested exclusively in Congress and not by the president. And both of these issues arise from the text of the Elections Clause of Article 1, Section 4, which states the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. And this is the phrasing that was chosen here is very specific, and it's not an accident. I'd say it's best explained by Alexander Hamilton in Federalist 59. And to quote him, he said, "There were only three ways in which this power could have reasonably been modified. Excuse me, could have been reasonably modified and disposed. That it must either have been lodged wholly in the national legislature, or wholly in the state legislatures, or primarily in the latter and ultimately in the former. They have submitted the regulation of elections for the federal government in the first instance to the local administrations, which in ordinary cases, and when no improper views prevail, may be both more convenient and more satisfactory. But they have reserved to the national authority a right to interpose wherever extraordinary circumstances might render that interposition necessary to its safety." So that's that's sort of the scheme that the framers of the Constitution in the 1787 convention came up with. And some of the concerns of the convention delegates were that the states might be able to incapacitate Congress if they held sole authority to regulate congressional elections. And this was already a point of contention for the United States Senate, which originally, until we ratified the 17th Amendment, was U.S. senators were appointed by the state legislatures. So allowing unreserved control over House of Representative elections to the states seemed a little gratuitous because the states already have total control over who gets to be in the United States Senate, and letting them have total unreserved power over House elections seemed to be kind of there was a fear that the House of Representatives might end up becoming an additional Senate. So that was the reason why this compromise was made. And this is perhaps best interpreted in a 1997 case in the Supreme Court called Foster v. Love, in which the Elections Clause is interpreted as such. Quote, "The clause is a default provision. It invests the states with responsibility for the mechanics of congressional elections, but only so far as Congress declines to preempt state legislative choices." So it's pretty clear that this is exclusively a congressional power. Now, could Congress, if Congress were so inclined, enact legislation to prohibit mail-in ballots and electronic voting machines, which was another, the discourse has mainly been about the mail-in ballot portion, but the president did also announce at the same time in the same Truth Social post that he's going to be trying to ban electronic vote tabulating machines. So if Congress wanted to do this, could they? And the answer is, it certainly seems like it. There's nothing in the Elections Clause that would take away congressional power to make all ballots hand counted and to make all voting done on election day, and to get rid of mail-in ballots or absentee ballots, early voting. Of course, Congress can only do this for congressional elections, but they certainly could, and that's because of the use of the word in the Elections Clause, manner. It's sufficiently broad to cover both prohibiting mail-in ballots and electronic voting machines, though it's certainly not all-encompassing. For instance, voter qualifications and candidate ballot access is beyond the scope of Congress's power under the Elections Clause. This was a point discussed at some length by Justice Scalia in the majority opinion of the 2013 case, Arizona v. Intertribal Council of Arizona. Uh, but
Wow.
to quote but to quote Chief Justice Hughes in the 1932 case of Smiley v. Holm, quote, it cannot be doubted that these comprehensive words embrace authority to provide a complete code for congressional elections, not only as to times and places, but in relation to notices, registration, supervision of voting, protection of voters, prevention of fraud and corrupt practices, counting of votes, duties of inspectors and canvassers, and making and publication of election returns. In short, to enact the numerous requirements as to procedure and safeguards which experience shows are necessary to enforce the fundamental right involved. So Congress has the power to preempt these state laws for sure, but it doesn't really help the president's case for unilateral presidential action. But oddly enough, he has already attempted to do this. In March, he issued an executive order purporting to require states to collect documentary evidence of U.S. citizenship for voter registration, as well as other things, such as prohibiting the counting of mail in ballots received after Election Day, which many states authorize. It was immediately challenged by a dozen or so states, if I'm not mistaken, and was successfully enjoined, principally on the grounds that the president has no authority to override state election laws absent an act of Congress to that effect. In particular, on the proof of citizenship requirement for voter registration, that one had ironically already been adjudicated 12 years ago in a case I already mentioned, Arizona v. Intertribal Council. And that case, again, the majority opinion authored by Justice Antonin Scalia, the Supreme Court held that the registration form prescribed by Arizona state law, which had a proof of citizenship requirement as part of registration, it was preempted by the National Voter Registration Act, which had no such requirement. So even though the elections clause doesn't allow Congress to preempt for who gets to vote in an election and state regulations as to that effect, though other parts of the Constitution, like the 14th or 15th Amendment, could. The elections clause doesn't. But the fact that the National Voter Registration Act said you must use this ballot, and then Arizona said, no, we're going to use this ballot that has a proof of citizenship, or excuse me, not ballot, this form, and Arizona says we're going to use a different form that has a proof of citizenship requirement. Well, that was preempted by federal law. And just like how states can't just unilaterally say, we're going to do something different from what the National Voter Registration Act says, the president also can't say, we're going to force states to do something different from what the National Voter Registration Act says. So it's a similar dynamic. This is an exclusively congressional power. And that's kind of the long and short of it. That's just about all there is.
Well, that's about all there is on the election clause. Is there anything else that Trump could do through executive order to try and affect how voting takes place in states?
Well, not really, but I do have some theories as to where this might be going. If we
Mm.
do eventually see anything come of this, one conjecture I have is that maybe we could see an attempt to invoke Section 2 of the 14th Amendment, specifically the part of it known as the penalty clause. And and here's what it says. When the right to vote at any election for the choice of electors for president and vice president of the United States, representatives in Congress, the executive and judicial officers of a state, or the members of the state legislature thereof, is denied to any of the male inhabitants of such state, being 21 years of age, and of citizens of the United States, or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age in such state. So that's what's sometimes called the penalty clause, and you can scratch out the portions that say 21 and put 18 because we amended the Constitution to lower the federal voting age to 18, and also we expanded the franchise from just men to women as well. So the language is a little bit out of date, but this is still part of the 14th Amendment. And it has never been enforced by Congress. Congress has never passed any law purporting to execute this provision. And it's only ever been seriously litigated in a federal court one time in a case called Saunders v. Wilkins back in 1945. And this is kind of a really fascinating case, and it also ties into Virginia, where we are. Uh, this was a challenge to the machine of segregationist Harry Byrd, and it was a challenge to his regime's disenfranchisement schemes through poll taxes, literacy requirements, as well as Virginia's relatively unique requirement of a political knowledge test, all of which enabled aggressive curtailment of electoral participation, which was the underlying point, even though the Byrd machine would deny it vociferously. And while it disproportionately affected Black voters, it necessarily resulted in many poor and low income white voters being turned away from the polls as well. So in 1945, a case was brought against the Secretary of the Commonwealth, who was at the time our chief election administrator, arguing that these restrictions on suffrage were de facto denials to the right to vote, thus causing the penalty clause of Section 2 of the 14th Amendment to take effect. And they argued that this should reduce Virginia's apportionment in the House of Representatives as a penalty for all of this rampant disenfranchisement. So the Fourth Circuit Court of Appeals, in this case, held that the provisions of Section 2 of the 14th Amendment were non-justiciable political question. It was a non-justiciable political question, which essentially says this isn't self-executing. We need Congress to enact a law telling us how to do this because it's a political question and it's non-justiciable. So Congress never acted on it after that. They've never done anything with it since. They never did anything with it before, and it's been sitting dormant ever since. Now, I want to make it abundantly clear. This doesn't help the president's case at all. Once again, this is something that would unequivocally require an act of Congress, and the executive has no independent authority to enforce it just at all. But I hypothesize that this might be an alternative to the election clause for three reasons. First, the administration already tried to invoke an independent or autonomous executive authority under the elections clause, and it was immediately shut down. As I mentioned, there was an executive order back in March that wanted to add documentary proof of citizenship requirements, among other things. That was shot down immediately in the courts. So it is clear that, you know, the administration does look to certain provisions and argue that the president can unilaterally execute those provisions absent an act of Congress. Second, it would be thematically consistent for the second Trump administration, which has demonstrated a penchant for finding obscure and long dormant laws and attempting to repurpose them in novel ways to achieve the president's objectives. The foremost example of this is the Alien Enemies Act, which hasn't been invoked since World War II and has only been used on 3 occasions throughout American history since it was enacted by Congress back in 1798. So it's not something that was really applicable to the situation, but it was revived in order to kind of shoehorn it into meeting an objective. And then third, in just the past few weeks, and I think this is perhaps the most important part of my argument, the president and his surrogates have been publicly expressing a desire to conduct a new census that would identify non-citizen respondents who are residing within the United States. The rationale being that states in which Democrats hold most or all of the congressional seats are allegedly inflating their apportionment in the House of Representatives through the presence of non-citizen inhabitants. This objective has a lot of legal problems on its own that I'm not going to get into, but first and foremost is that even if an interim census were conducted and identified all of the non-citizens, and they were in fact wholly concentrated in so-called blue states, the Constitution still prohibits reapportionment outside of the decennial census schedule. But theoretically, the penalty clause of Section 2 of the 14th Amendment provides for a non-decennial reapportionment if a state disenfranchises part of its electorate. So it occurred to me that the administration might try and attempt to merge the president's grievances with congressional apportionment with his grievances regarding mail-in ballots and electronic vote tabulating machines. And they could rely on very dubious allegations about mail-in ballots enabling vast numbers of non-citizens or unauthorized migrants to vote in federal elections. And they could use that as a predicate to argue that mail-in voting constitutes an abridgment of voter suffrage pursuant to the 14th Amendment and invoke Section 2's penalty upon states that are accused of having a high number of non-citizens present. Now, I want to make it abundantly clear, this would be totally absurd, extremely illegal, but I still wouldn't rule out the possibility of an executive order proffering an ultimatum to the states: repeal your mail-in voting laws and get rid of your electronic vote tabulating machines, or have your congressional seats reduced by presidential fiat. Again, there's zero authority for the president to reduce a state's apportionment in Congress unilaterally, but there's also no authority to outlaw voting by mail through the elections clause either. So, I mean, either one is just as plausible as a theory of executive power. So, and the logic I'm using is, well, basically, when those who hold power divorce government authority from both law and fact, well, then they don't really perceive any limits on the power of the state. And in order to try and foresee what might come next, you can't simply look at the letter of the law to identify what it authorizes the government to do versus what it constrains. Instead, you have to look at the ways in which the law can be wielded as an instrument of power and repurposed to achieve whatever is desired in the moment. And when law is treated merely as an instrumentality, what matters most is guessing what might come next are the patterns and the thematic elements of the narrative being propagated to justify wielding power far beyond what the law permits. So that's just one hypothesis. And it could be that this was just the president speaking off the cuff and we never hear anything about it again. It's also a possibility. We're just gonna have to wait and see. It's more just speculation, but I think some of the media coverage on this has just kind of said the president has no ability to do this. End of story. I mean, it's true, yeah, but I feel like it's helpful to kind of get into the nitty gritty and some of the details on it, because in the media, has kind of shot themselves in the foot one too many times for people to just say, yep, I trust that. So that I've just supplemented a little bit with, and you don't have to, take a position on whether or not this is a good thing or a bad thing. You don't even have to like mail-in voting. I mean, you can hate it, but the best way to do that is to get in touch with your member of Congress and say, I have concerns about mail-in voting. Please preempt state laws regulating it. And that's totally 100% kosher. And you won't hear any pushback from me on your doing that, because that's what the Constitution permits. So, but that's my story, and I'm sticking to it.
So, well, that's a lot of really interesting information. But, if we're going to form opinions, it's best to be able to form opinions on what is really true and not just what someone else says they think might be true. And with the media and social media bombarding us, it's so hard to get down to what the true facts are. So, first question, would you be able to give me links to some of those documents and court cases that you referenced so I can put those
Oh
in the
yeah.
comments?
Oh yeah, yeah,
Okay.
yeah. We can put all those in the description, and I'll format them in the order that they were brought up. But because I went and double checked all of these things. Like, I was familiar with Saunders v. Wilkins in advance, just because it's a really fascinating chapter of Virginia history. It's surprising how many important landmark cases came out of Virginia. Even the entire concept of judicial review is part of our early post-revolutionary tradition. We're the progenitor of judicial review here in Virginia. So I
Yeah.
was familiar with it already, but I'm going down another rabbit hole. So, but yeah,
So,
I can do
well,
that, no problem.
let's save the next rabbit hole for another video. And we all know here in Virginia we have a rich history, and it's something we want to protect the knowledge of that history and make sure that people understand. And I don't want to tell people how to think, but I do like being able to share information that helps them make an informed thought process. So thank you so much for sharing all that with us, Zach. And I'll get this
Yeah,
pulled
and
together. And
yeah,
did
on the
you have
mail-in
any?
voting. Well, yeah, on the mail-in voting thing though, I know uh, that you always vote early, and
Oh, that's
and
right.
and
I
I think
told
that
you
might be
that.
interesting for yeah. I thought it's kind of relevant to it, and this is something that you do, and I think it's kind of interesting, and it's a perfectly valid point. Because we don't just want to beat up on someone who if you have concerns about the growing trend of voting earlier and earlier and earlier. uh it's it's perfectly valid to think that there may be some concerns, and I know that you always vote as early as possible, and I know you
Oh,
might elaborate on that.
I'm there the first day of early voting. I'm one of those crazy people in line when the doors open, and there's a reason for that. The mail-in ballots here in Virginia, I do know that we have really good safeguards in place to make sure that when the ballot comes, it's in two envelopes. You have one envelope that does not identify the sender, and that envelope goes into the mail envelope. And so when they're open and separated, a great care is taken because once that vote goes into the machine, you can't get it out. So they don't even count those until after election day ends. So, but my biggest concern was not actually with mail in voting, but with the early voting, because in Virginia, we say the law still clearly says you have to have an ID to vote. And when you go to vote or you get a provisional, and we've lengthened the list, and there are all kinds of things that you can use for IDs from utility bills that have the same mailing address, a lot of different things you can use for IDs. That's one part. But what concerned me most is if someone doesn't have an ID, they can simply sign a paper swearing they are who they say they are. So the way this plays out is someone could go to vote, knows my name, knows where I live, say they're me, and there are no cameras, no pictures, no videos. We don't know who the person would be. But someone could go in, say they're me, give my address. Oh, I don't have an ID with me. I don't have anything. But the person can sign a statement that says, I solemnly swear I am Karen Greenhall, and sign it. And that person is given my ballot. And that person can fill in my ballot and put it in the machine. So then days later, when I show up to vote, um, I'm given a provisional because I was told I already voted. So even if after the election my provisional is deemed valid and they put it in, they can't get out the first one. So that skews the vote. So I am there on election day when the doors open in line so that I can vote before somebody goes and says they're me. And that's just me. I don't even, I don't know of anyone who would do such a thing. But my vote is so important to me that I make sure I'm the one that gets to cast it. So at any rate, did you have anything to add, Zach?
Oh yeah, yeah, and I think that that's a valid point. I mean, and I don't want to tell someone that if they have concerns about mail-in voting or something. I don't think it's helpful to just shoot them down and say, oh, you're a conspiracy theorist or something. Uh, and while it is true that there is no evidence that there's ever been any large scale fraud, but at the same time, it's important to recognize that the reason why it's a crime to do what you described, to like
Mm-hmm.
if you get a mail-in
Mm-hmm.
ballot that's not yours in the mail by accident, and you're like and you say, ooh, I get two votes, and you send that in, it's a felony offense. You can end up behind bars for that. And it's fortunately impossible to do at a large scale, but in theory, you can do it for a single vote. And that is bad, but it can't be done
Yeah.
at a large scale. And if you do it, it's a high exposure crime, because if someone shows up to the polls and they say, and the poll worker says, well, the poll books say you already voted. Well, then immediately there's a discrepancy. And
Yeah.
at some point, someone's going to get in front of, a detective with the local police department, and they're going to, trace it back and figure out, where was this mail-in ballot sent. And there's a high chance that, if someone takes advantage of getting a hold of a mail-in ballot like that, and doesn't go and turn it in or shred it or destroy it or, do the right thing, they could end up getting a very stiff penalty. And
Oh, but you
that's the
do
reason
know
why it's a crime. Yeah, I
if
mean,
you get a mail-in ballot and you decide you want to go vote in person, you're supposed to take that ballot with you and turn it in so that they know nobody else got it. So,
yeah, yeah. So yeah, there are voluminous safeguards in place. So I think it's always important to never just write someone off for having concerns, and it's more important to kind of get into the details of what exactly it is that happens when a mail-in ballot is sent out and when it's received, and how discrepancies are resolved and what the actual risks are, because
yeah.
it would be lying to say that there is no risk of a fraudulent vote not being counted. But the way that it's designed is that it prevents that happening at a large scale because every single ballot is individually tracked, or when tracked, it has its own barcode, serial number on it. Different states call them different things, but there's a fixed number of ballots that prevents these from being intercepted at a large scale. And doing that and intercepting a mail-in ballot, very high risk crime. And but there's also the reason why it's a crime. If there was no risk of it happening, then you wouldn't need to criminalize it.
Well,
So
and that's why we're so careful. In Virginia, we recognize every single vote counts. And I want people to go vote. I hope we haven't scared anyone off from voting. That's not the thought. Not at all. We
no,
want
no, not
everyone
at
to go
all.
vote. Yeah. And so Zach, I'll ask you one more favor. If an executive order about this comes out, will you come back and give us your
No,
views?
yeah, yeah.
Okay.
I'm really interested in seeing how it goes, just because it occurred to me that this might play into some earlier statements that the president had made on Truth Social, and it's it feel kind of like a palm reader. So I'm interested in seeing whether my predictions come correct. So
It'll be really interesting to see. It may come to nothing, in which case we'll talk about something else. But at any rate, thank you so much for joining us, Zach, and thank you to everyone who watched the video. Make sure you check the notes below, and I'll put information about Civic Innovations and what we're doing here. One of the things that we do is help people register to vote, encourage them to vote, and we actually teach classes for people to learn how their government works and how they can make sure that their representatives hear what they have to say. So thank you so much, and I hope everyone will comment, and we will see you soon. Thank you.
all right, thanks.